Okay, so today we're diving into something that I think a lot of people find pretty overwhelming.
Yeah.
And that's dealing with evictions in California, especially from the perspective of being a tenant.
Right.
So, if you're renting here in California and you get hit with an eviction notice,
Yeah.
it can feel like a lot of uncertainty. Like, where do you even begin?
Absolutely.
What are you supposed to do? What are your rights?
Tons of questions.
So many questions.
Yeah.
And that's why we're here today, to kind of cut through some of that confusion.
Exactly. This deep dive is all about giving you some really clear, essential information about the laws around evictions here in California.
Yeah.
And we're really focusing on your rights as a tenant and the actual process itself, so you can kind of get a grasp on what's going on and what you can do about it.
Absolutely.
Yeah.
So to do that, we've gone through and looked at all the kind of key parts of eviction law here in California.
Yeah.
And the goal here is to really give you a solid understanding of what you can expect. And importantly, highlight the potential defenses that you have.
Yeah.
If you find yourself in that situation where you're facing eviction.
Yeah.
So think of this as like your essential guide to navigating this whole process, which can be really challenging.
Exactly. And one thing that's vital to understand right off the bat is that eviction in California, it's not, just a casual thing where the landlord asks you to move out.
Right.
It's a very formal legal process called an unlawful detainer.
Okay. Unlawful detainer.
Yeah. And that basically means there are specific rules and procedures the landlord has to follow. They can't just, change the locks on you.
Okay. So that sounds very legalistic.
Yeah.
So what does an unlawful detainer process? What does that actually look like for a tenant?
So essentially the term itself, it means the landlord believes you're unlawfully holding possession of the property.
Got it.
So to get you out legally, they have to adhere to all these strict notice requirements and follow this, kind of a pathway.
So they can't just skip steps.
They cannot skip steps.
Okay, so walk me through those steps then. What are the general steps a landlord have to go through to legally evict someone in California? What should I, as a tenant, expect?
So it always begins with a written notice from the landlord.
Okay.
And this notice has to state the reason they want you to leave.
Okay.
Now, if you don't take action based on that notice, so either by fixing the issue, if that's possible, or moving out, the landlord's next step is to actually file a lawsuit with the court.
Okay.
And this lawsuit, it's formally called a summons and complaint.
Right.
And it's crucial that you as the tenant are officially served with these documents.
Okay, served. So what does that mean? Can they just email it to me or tape it to my door? How does that work?
No, they can't. There are specific legal rules about how you have to be served.
Okay.
It's to ensure that you actually receive notice of the lawsuit.
So they have to hand deliver it?
Yeah, generally they have to hand it directly to you or someone of suitable age at your home.
Got it.
And there are rules about how many attempts they have to make and all that. Mm-hmm. So if you don't feel like you were properly served, that's something to look into.
Definitely.
Now, once you are served, you only have a limited time to file a response with the court.
Oh, really? How long do you have?
Typically just 5 calendar days.
5 days? That doesn't seem like very long.
It's not much time. So you need to treat that summons and complaint like a ticking time bomb. Because if you miss that deadline, you can automatically lose, even if you have a really good defense.
Wow. That seems pretty stressful. 5 days is not a lot of time.
No, it's not, which is why it's so important to understand that timeline.
Right.
But if you do file a response on time, then the case will likely move towards an actual trial.
Okay.
And at the trial, both you and your landlord can present your arguments and any evidence you have to a judge.
Got it.
And if the landlord wins at trial, the court will issue a judgment.
Okay.
Which states that they've won and they have the right to take back possession of the property.
Oh.
And they'll also issue a writ of possession.
Okay, a writ of possession, what is that?
So that's basically the court's final order, and it directs the sheriff to physically go to the property and post a notice.
Okay.
Giving you one last chance to move out voluntarily.
And what happens if you still don't move out at that point?
At that point, the sheriff has the authority to actually physically remove you from the property.
Okay.
And hand possession back over to the landlord.
Got it.
So it's a very structured legal process, and it's designed to provide some level of due process,
right,
even though it can be very overwhelming when you're the one going through it.
Absolutely. So that's the how of the eviction process.
Right.
But I think it's also really important to understand the why.
Yeah.
Why can a landlord even start this whole process? What are the legal reasons they can evict someone in California?
So the most common reason by far is non-payment of rent.
Okay, that makes sense.
So if you fall behind on your rent, that gives the landlord grounds to begin the eviction process.
Right.
Another really common reason is violating the terms of your lease agreement. And this can cover a lot of different things.
Give me some examples.
So, for example, having a pet when your lease specifically forbids it.
Okay.
Or having someone living with you who's not officially listed on the lease as a tenant.
Got it. What are some other examples of lease violations that could get you evicted?
Sure. Repeatedly making a ton of noise that disturbs your neighbors.
Oh.
Operating a business out of your apartment when that's not allowed.
Right?
Making alterations to the property without getting permission.
Okay, so unauthorized construction or something like that.
Exactly.
Okay, are there other things that could lead to an eviction?
Yeah, definitely. Illegal activities on the property are grounds for eviction, as is causing significant damage to the property.
Okay, beyond just normal wear and tear.
Right, beyond normal wear and tear.
Got it.
Or creating a nuisance that really disturbs other tenants.
Right.
Also, if you have a fixed term lease that's expired and you refuse to find a new one, that can be a reason.
Okay.
Or having an unauthorized subtenant living there.
Got it.
And lastly, in certain situations, a landlord can evict if they have a good faith reason to repossess the property themselves.
What would be an example of that?
So maybe they need to do major renovations that require the unit to be empty.
Okay.
Or they're going to demolish the building.
Right.
Or a family member is going to move in.
Got it. So it's a lot more than just not paying rent.
It's a wide range of things.
There are a whole bunch of reasons a landlord might start this eviction process.
Exactly.
Okay, so you mentioned these notices a landlord has to give.
Right.
It seems like the specific type of notice a tenant gets is really important.
It is.
So can you walk me through like the different kinds of notices a landlord might give before they can even file that lawsuit?
Absolutely. So the type of notice you get depends entirely on the reason they're evicting you.
Okay.
So for non-payment of rent, the standard one is a 3-day notice to pay rent or quit.
3 days to pay rent or quit.
Yeah. And that gives you exactly 3 calendar days to either pay the full amount that's overdue or move out of the property.
Got it. And it has to be very specific. It has to state the exact amount of rent owed, the name, phone number, and address of whoever you should pay, and the dates the rent was due.
Wow. So very specific.
Very specific.
So what if the issue isn't about unpaid rent?
Okay, so if it's about violating the lease agreement,
like the unauthorized pet we were talking about.
Exactly. Then the landlord will typically serve you with a 3-day notice to cure or quit.
Okay, cure or quit, so you have a chance to fix it.
Exactly. So this gives you 3 days to either correct the violation,
like get rid of the pet.
Right. Remove the pet or move out.
Got it.
However, for some more serious violations, the landlord can issue a 3-day notice to quit.
And there's no chance to cure on that one.
No, there's no option to fix it. You just have to leave within those 3 days.
Okay, so that's reserved for like really serious stuff.
Yeah, really serious stuff like major damage to the property or illegal activity.
Got it. So those are all 3-day notices?
Right.
Are there ever situations where a tenant would get more time? Yes, for month-to-month rental agreements where there's no fixed lease.
Okay.
The landlord has to give more notice.
How much more?
So if you've lived there less than a year, it's typically a 30-day notice to quit.
30 days. Okay.
But if you've lived there for a year or more, then it's a 60-day notice to quit.
Okay, so that's a lot more time.
It is.
And these longer notices are usually used when the landlord just wants to end the agreement without any specific reason.
Exactly. They're not alleging any fault on the tenant's part. They just want to end it.
Okay, so all this really highlights how important it is for tenants to really read and understand any notice they get from their landlord.
Absolutely.
But what happens if the landlord makes a mistake on the notice, like they get the dates wrong or the amount of rent owed? Is that something a tenant can use as a defense?
Yes, absolutely. Improper notice can be a huge defense for tenants.
Interesting.
So if the landlord doesn't give you the correct type of notice for the specific reason they're trying to evict you,
Okay.
or if the notice is missing crucial information like the exact amount of rent owed,
or the specific lease violation, or if it wasn't served properly,
right,
then the whole eviction case could be challenged and potentially even dismissed.
Wow. So it's really important to pay attention to all those details.
The law is really strict about these notices because they're meant to give you a fair chance to respond.
Okay, so we've talked about improper notice. What are some other important legal defenses a tenant might have if they're facing an eviction? I mean, this is really crucial information for anyone listening who might be in this situation.
Absolutely. So beyond the notice itself, another big one is the landlord's responsibility to maintain the property.
Okay.
So in California, landlords are legally required to make sure your living environment meets basic standards.
What kind of standards?
It has to be free from serious health and safety hazards.
Okay.
Functioning, plumbing, and heating structurally sound.
Got it.
So if your landlord fails to address major problems,
Like what kind of problems?
mold infestations, lack of hot water,
Yeah.
big structural issues.
That's major stuff. Right. And you've notified them in writing and given them reasonable time to fix it, then withholding rent can actually be a valid defense.
Oh, really? So you're not just automatically in the wrong if you withhold rent?
Right. It depends on the circumstances. And you have to have documentation of your communication with the landlord.
Okay, so you can't just decide not to pay.
Exactly.
It has to be because of these unaddressed issues.
Correct.
Okay, now I've heard about something called repair and deduct.
Yeah.
Can you explain how that works?
So repair and deduct is a specific legal remedy for tenants in California.
Oh, wait.
If your landlord doesn't make necessary repairs to make the unit habitable.
After you've given them notice and all that?
Right after you've given them reasonable notice,
Uh-huh.
you can pay for the repairs yourself and deduct it from your next rent payment.
Okay, so you front the money and then take it off your rent.
Exactly. But there are some important limitations on this.
What kind of limitations?
First, the repairs have to be for things that actually make the place uninhabitable.
Okay, so not just cosmetic stuff.
Right, it has to be serious.
Uh-huh.
And you can't deduct more than 1 month's rent to cover the repairs.
Okay, so there's a cap.
Yeah. And also, you can't have caused the damage yourself.
Right.
And lastly, you can only use this remedy twice a year.
Okay, so it's a tool you have, but it's limited.
It is. So you have
Yeah.
to be careful how you use it.
Makes sense. So besides improper notice and the habitability issues, what other key defenses should tenants in California be aware of?
Well, if you get a 3-day notice to cure or quit for a lease violation, and you actually fix the problem within those 3 days, then the eviction shouldn't go forward.
Right, you cured the issue.
Exactly.
Okay, what else?
Another really important one is that it's completely illegal for a landlord to evict you based on discrimination.
Oh.
So that includes discrimination based on your race, religion, gender, sexual orientation, disability, family status, all those protected characteristics.
Right.
If you think the eviction is motivated by discrimination, then that's a strong defense.
Absolutely. And what about if the landlord is retaliating against you for something?
That's also illegal in California.
Okay.
So if you complain to the housing authority about bad conditions
Oh,
or requested repairs,
right.
and then the landlord tries to evict you because of that, that's considered retaliation.
Okay. And that can be used as a defense.
Yes. And there are specific timelines for these retaliation claims, so you have to act quickly.
So document everything.
Exactly. Documentation is key.
Okay, so we've talked about all these legal processes and defenses, but what about those situations where a landlord tries to just take matters into their own hands?
Yeah, that's big no-no.
Like bypass the courts altogether?
Exactly. So in California, landlords are absolutely prohibited from engaging in what are called self-help eviction tactics.
Okay, what are some examples of that?
So things like changing the locks on you shutting off your utilities like water or electricity, or physically removing you or your belongings without going through the courts.
Okay, so those are all illegal.
They are very illegal.
And if a landlord does that, what can a tenant do?
Well, first of all, those actions are unlawful, and they can also be used as a defense against any eviction lawsuit the landlord tries to file.
Okay.
And in some cases, the landlord could even be held liable for damages to the tenant.
Wow. Okay, so definitely don't let a landlord get away with that stuff.
Absolutely know your rights.
Okay, so we've covered a lot of ground here, but I know there's one more really important situation I want to ask you about.
Okay.
What happens if you're renting a place and the property goes into foreclosure? Are there any special protections for tenants in those cases?
Yes, there are both federal and state laws that protect tenants in foreclosure situations.
What are those laws called?
So there's the Federal Protecting Tenants at Foreclosure Act, that's PTFA,
Okay, PTFA.
and the California Homeowners Bill of Rights, or HBR.
HBR, got it.
And these laws provide some important safeguards for tenants.
Like what kind of safeguards?
So generally what are called bona fide tenants.
Okay, what does bona fide mean in this context?
It usually means you have a legitimate lease that was signed before the foreclosure started. You're paying rent that's close to market value.
Right.
And you're not the former owner or relative living there without a lease.
Got it.
So these bona fide tenants are usually entitled to at least a 90-day notice to vacate the property after the foreclosure sale is final.
90 days. Okay, and what if your lease runs longer than that?
In many cases, if you have a fixed-term lease that extends beyond those 90 days, you have the right to stay until the end of your lease.
Okay, so the foreclosure doesn't automatically mean you're out on the street.
Exactly. You still have rights.
So are there any exceptions to that 90-day rule or the right to stay for the rest of the lease?
Yes. The main exception is if the new owner who buys the property at the foreclosure sale plans to live there themselves.
Okay.
They can terminate your tenancy with a 90-day notice, even if your lease hasn't expired yet.
So even then, you still get the 90 days?
You're still entitled to that 90-day notice period.
Okay, got it. So foreclosure is definitely something to be aware of, but it's not an automatic eviction for tenants who are following the rules.
Exactly.
Okay, so this has been a lot of information about evictions in California.
It is a complex area of the law.
It really is, and I think it highlights how important it is to have an attorney on your side if you're going through this process.
Absolutely.
So for a tenant who's facing eviction, how can having an eviction attorney actually help them?
I mean, an eviction attorney can be an invaluable resource in this situation.
Yeah.
First and foremost, they can give you specific legal advice for your situation.
Okay.
They can explain your rights and your obligations under California law.
So they really know the ins and outs of all these laws we've been talking about.
Exactly. And if you believe you're facing an unlawful eviction, like one based on improper notice or discrimination or retaliation, an attorney can help you build a strong defense.
So they're really like your advocate through this process.
Exactly. They're there to guide you through this legal maze.
But what else can an attorney do?
Well, they can represent you in court.
Okay.
Just make sure all the documents are filed correctly and on time, and that all the rules are followed. They can cross-examine the landlord and their witnesses in court.
Okay.
Really challenge their claims and present your side of the story effectively.
And can an attorney help with negotiating with the landlord?
Absolutely. A good eviction attorney can be a huge asset in negotiating a settlement.
What kind of settlement?
Well, it might involve you avoiding eviction altogether, or at least getting more time to find a new place and move out.
Okay, so that could be really helpful.
Absolutely. Having an experienced attorney really increases your chances of a favorable outcome.
Got it. And I understand that the Martinez Law Center in Santa Ana specializes in representing tenants in these cases.
We do. We focus on helping tenants understand and protect their rights.
And people can find more information on their website.
Yes, it's martinezlawcenter.com.
Okay, so let's recap some of the key points we've covered today.
Okay, sounds good.
Just as a reminder for tenants in California who might be facing eviction, remember that eviction is a formal legal process. It's called an unlawful detainer.
Right.
And there are very specific rules and timelines that the landlord has to follow.
Yes.
Make sure you understand the common reasons why a landlord can evict you. And pay very close attention to the details on any notice you get from your landlord.
It's so important.
Because any mistakes or missing information on that notice can actually be a legal defense for you.
Absolutely.
You also need to be aware of your rights if your landlord isn't maintaining the property in a safe and habitable condition.
Right.
And never forget that you can't be evicted because of discrimination or as retaliation.
Those are key points.
And those can be very strong defenses in court.
Exactly.
And finally, if your rental property is going into foreclosure, you likely have specific protections under the law.
Yes, both federal and state laws.
So that was a lot of information. And it can feel a bit overwhelming, but I think it's really important for people to know.
I agree. California law offers a lot of protections for tenants, but you need to know what they are and how to use them if you need to.
Absolutely. This is really about empowering tenants to understand their rights and protect themselves.
Exactly.
So if you are facing eviction or if you just have any questions at all about your rights as a tenant, we really encourage you to visit the Martinez Law Center's website.
Yes.
That's martinezlawcenter.com.
They can give you valuable information and help you explore your options for legal help.
And remember, everyone, your tenancy, it's more than just a roof over your head.
It is.
It's your home. It's your stability.
It's your security.
Exactly. So understanding your rights under California law is the best way to protect that.
It's the key to defending your home and your peace of mind.
Absolutely. Well, thank you so much for taking the time to walk us through all of this.
You're very welcome. I'm glad we could help clarify some of these complex issues.
I think this has been really helpful for our listeners.
I hope so.
And I hope everyone stays tuned for our next deep dive. where we'll be tackling another important topic.
Sounds good.
Until then, be sure to check out martinezlawcenter.com for more information about tenant rights in California.
And remember, knowledge is power when it comes to protecting your home.
Call now 714-442-9741. Thank you.